Good evening to everyone who's joining us. I think I might just give it a couple of minutes before we actually start this webinar, just to make sure that we can admit everyone into the main room. So just give it a couple of minutes. Right, I'm going to make a start. So hello and good evening to everyone who has joined us for today's session on weddings law reform. My name is Nazia Rashid and I shall be your host for this evening session. In terms of formalities for today, we have allowed an hour and 15 minutes for today's session, and I will gently remind each speaker to keep to their allocated time, as we have a lot to cover in a limited amount of time. All attendees will be muted and the session will be recorded. Questions and issues that we have received in advance of today have been incorporated. If you still have a question after today's session, feel free to email that to us, and if it has not been answered today, we will reply to the same. Now, as you know, we find ourselves in the middle of Interfaith Week. And as a reminder, the aims of Interfaith Week are to strengthen good interfaith relations at all levels, increase awareness of the different and distinct faith communities in the UK, and to increase understanding between people of religious and non-religious beliefs. So in light of this, my guest speakers and I thought it would be a good idea to have a discussion on weddings law reform and how it could have an impact on various religious belief-based communities. I'm sure we will all agree that more often than not, weddings are a time of immense celebration and excitement. So there is no surprise that one might not stop to think of the legal consequences of the intended ceremony. But there will also be scenarios such as in the widely reported case of Akhtar and Khan, which concluded in 2020, where parties to a religious marriage are fully aware of the legal status of the ceremony, but having relied upon a promise of a later civil marriage, which was unfulfilled, find themselves in what is now termed as a non-qualifying ceremony of marriage, which is a better term than a non-marriage, as was previously the case. But nonetheless, the non-qualifying ceremony status has not changed the inability to access primarily the Matrimonial Causes Act 1973, which can provide for fair and generous financial settlements and make orders in respect of spousal maintenance and pension orders, to name a few. The Law Commission consulted on weddings law reform, and it is my understanding the Commission is due to fully report by the end of this year. If I can now turn to introduce my guest speakers for today. Elizabeth Welch is a lawyer at the Law Commission and was previously involved with the Commission in the 2015 scoping work on weddings, and is the lawyer leading the current review. Professor David Hodson is a founding partner of the International Family Law Group, and I have worked with David on various projects for more than a decade now. David is an English solicitor, mediator, arbitrator, and part-time family court judge at the Central Family Court, to name a few of his roles. He is the editor of and primary author of the textbook, The International Family Law Practice, which I will add, I also contribute to by way of a chapter on Islamic family law. Graeme Fraser is a solicitor, partner, and head of the family department of OGR Stock Denton LLP, and specialises in complex financial remedies and cohabitation claims. Graeme is chair of Resolution's Cohabitation Committee and has dedicated his career to improving protections for cohabiting couples. Dr. Rajnaara Akhtar is an assistant professor at the University of Warwick. Her research centres on marriage formalities and legal treatment of non-legally binding religious-only marriages. She is currently leading a grant-funded research project, which we shall hear more about later. Rebecca Probert is Professor of Law at the University of Exeter, and her research focuses on the law governing entry into marriage. Rebecca is a co-investigator on Dr. Akhtar's research project and specialist consultant to the Law Commission's wedding project. And myself, Nazia, I'm a partner at Anthony Gold based in South London, and I'm a family solicitor and mediator. And like my solicitor colleagues on today's panel, routinely undertake complex domestic divorce and family cases, and also cases with an international element. I'm co-chair of my firm's EDI committee and sit on Resolution's National EDI committee. As you will all appreciate, I'm sure, that a constructive discussion is one where panel members are able to express views and opinions freely. And it is important for all those participating today to accept differences and opinions in a respectful and meaningful way, which is important because of the progressive and diverse society we live in. So in terms of the structure today, it's divided into 5 parts. The first is in relation to the background to the Law Commission's work. The second part is in relation to key concerns in various religious faith-based communities. We will then have an outline of the proposed reform, and we will also consider other areas of reform which relate to the intimate, when an intimate relationship breaks down, and areas of law that might need reform further. And lastly, if time permits, we will touch upon questions that have been asked. So if I can now turn to Rebecca and to Elizabeth and ask, what triggered the Law Commission to consider weddings law as an area for reform? And secondly, in relation to the belief-based communities, what was of concern to the Commission that required further exploration?
Thanks very much, Nazia. So I'll start just first with a quick brief background to the Law Commission's current project, and then move on to the next question about the concern in relation to faith-based marriages. So there have been calls for wholesale reform of the law for some time, including in 1971, when a joint working party of the Law Commission and the Registrar General concluded that the law was complex and rationalization of the law was long overdue. Further impetus for reform came about during the debates on the Marriage Same-Sex Couples Act 2013, where the issue of marriages conducted by non-religious belief organizations, such as humanists, was raised, and as a consequence, government consulted on that issue. The Law Commission then agreed in 2015 to conduct a scoping paper, and that would identify the issues that would need to be addressed to develop proposals for reform of the law. In our scoping paper, which we published in December 2015, we concluded that the law was unduly complex, uncertain, and inefficient, and that it is perceived to be unfair and overly restrictive. These problems can have a profound effect on couples, including impacting on the validity of their marriage and preventing some couples from having a wedding that is meaningful to them, which I'll touch on in just a minute. And following on for this, we began our current project in the summer of 2019. We are now conducting a wholesale review of the law in order to make recommendations to government for reform, and we outlined provisional proposals for reform in a consultation paper which we published in September of 2020. I have the next slide, please, Nazia. Thank you very much. So one particular issue that we've been considering in our project in relation to belief-based communities is the significant issue that the law is perceived to be unfair and restrictive, which prevents some couples from having a wedding that is meaningful to them, recognized by the law. So this infographic, which is in our consultation paper, shows the different types of marriage according to the structure outlined in the current law of the Marriage Act 1949. I have highlighted some of the aspects that I will mention, and they focus on the different requirements of those different marriages outlined in the current law. So as you can see, the law requires couples to have either a civil wedding or a religious wedding. There is no option to have a wedding according to beliefs that are non-religious, which was the subject of government's consultation in 2014. The sharp distinction between civil and religious weddings in the law also does not accommodate couples who have different beliefs, including couples made up of persons of different faiths and couples where one person is religious and the other is not. Couples wanting an interfaith wedding under the current law will generally have to choose between a ceremony that reflects the faith and beliefs of one or a ceremony that reflects the faith and beliefs of neither. Nor can couples have their religious beliefs honored in a civil wedding because of the prohibition on religious service in civil ceremonies, which is highlighted on the infographic there. There are also the rules governing where various weddings can take place, which do not accommodate couples whose beliefs do not dictate that they marry indoors in particular types of venue. So with exceptions for Jewish and Quaker weddings, all religious weddings must take place in a place of worship. However, some religious groups do not see their place of worship as the best or most meaningful place to get married. And we understand that this includes some Muslims, Jains, Hindus, Buddhist, and pagan couples. Some of these couples would prefer to marry outdoors, in a restaurant or community center, or at home, for some examples. In addition, under the current law, all religious weddings, other than Anglican, Jewish, and Quaker weddings, must include specific prescribed words as a part of the wedding ceremony. And this requirement also causes concerns. We have heard from stakeholders that the requirement for prescribed words is seen as an imposition by some religious groups. This is particularly the case for those primarily non-Christian groups who developed their own forms of ceremony before those ceremonies were subject to law in England and Wales. The prescribed words are seen as an intrusive element that the law imposes on couples and are sometimes seen as requiring a separate civil ceremony within the larger religious blessing that's taking place. So all of these rules may be contributing to the significant issue of non-qualifying ceremonies, which Nazia introduced. Typically, these are weddings conducted according to religious rites that fail to comply with all or virtually all of the requirements outlined in the Marriage Act 1949. And so have no legal consequences or no legal status. This issue has been highlighted particularly in respect of Islamic religious-only weddings, but we understand that it happens in other cases as well. The lack of legal recognition can result in hardship, particularly on the breakdown of the relationship, because there is no entitlement to financial support that would be available when a couple who are legally married divorces. That hardship is experienced disproportionately, although not invariably, by women who have been financially dependent on their partners for the duration of the relationship, or where all of the assets are held in the man's name. An appreciation of this problem has been growing, including since we published our scoping paper in 2015, with, for example, the independent review into the application of Sharia law in England and Wales, which reported in 2018. And back to you, Nazia.
Thank you, Elizabeth. I'll go to the next slide. So we'll just move to the second part, which is in relation to key concerns in various religious faith-based communities. As Elizabeth has highlighted, there are three main routes into marriage. The first route is a religious route, and that is in relation to Anglican preliminaries, followed by an Anglican ceremony. The second one is a civil route, which is civil preliminaries followed by a civil ceremony, either in a registered office or on approved premises. The third one is more of a hybrid route, which are civil preliminaries followed by four forms of religious ceremony, which could be either in accordance to the usages of the Jews, according to the usages of the Society of Friends, or such form and ceremony as the parties wish, in a place of religious worship registered for the solemnization of marriage, or according to the rites of the Church of England. If I can turn firstly to Rajnaara. In much of the public discussion that takes place concerning wedding law reform and minority faith groups, marriage practices that often take place in the Muslim communities are often cited. We saw this in the Akhtar and Khan case, but the practice can also feature in cases which involve an immense amount of wealth. For example, in the case of El Gamal and Al Maktoum in 2011, the judge had to first determine whether an Islamic wedding ceremony which took place in a West London flat, did that take place, and if so, what its legal effect was, if any, under English law. The parties had one child, and the father was a very senior member of the royal family of Dubai. And very briefly, the judge considered that the mother would have been aware of the required formalities before one can be married in this country. And therefore, the ceremony did not amount to a void marriage, but it was held to be a non-marriage, which is now termed as a non-qualifying ceremony. And that was a marriage that was described as taking place in secret and lacked written evidence. So turning to you, Rajnaara, could you talk a bit more about what the key concerns you have found in the Muslim communities and say a bit about your research, please?
Thank you, Nazia. We can start with my first slide, which is a lovely winter scene, which I thought would be appropriate. It's nothing to do with weddings, obviously. So as we've just heard, the Law Commission is proposing sweeping reforms to how people marry. The project I'm leading, funded by the Nuffield Foundation, focused on those couples who are marrying with using non-legally binding ceremonies. So the most prevalent example of such ceremonies are religious marriages, such as the Muslim nikah. However, our project demonstrates that this is by no means limited to Muslim communities, and actually couples from a range of faith and non-faith groups also have dual ceremonies. So overall, the aim of the project was to find out who is opting for non-legally binding ceremonies, their reasons for doing so, the role of those who perform them, and the potential impact of different proposals for reform. So if we can just go to the next slide, please, Nazia. So just by way of overview, our research engaged 82 participants who conduct weddings, of whom 31 were conducting the nikah ceremonies. So these were mainly imams, but we also had 2 female participants. We also interviewed, we had 83 interviews with regards to specific weddings, and 33 of those interviews included a nikah ceremony as part of the wedding. And of those 33, 14 were religious-only marriages at the time of the interview, i.e. they didn't have the dual ceremony, it was just the religious ones. So there are several key concerns for Muslim communities, but due to the very short time of this presentation, I'm just going to focus on some key issues. Next slide, please, Nazia. So firstly, our research found that the wedding is very much seen as a journey for Muslim couples. So we found that the majority of the Muslim marriages involved having the nikah first. So most would then marry legally either closely following the nikah or within weeks or months of it. The majority of those who were in religious-only marriages also intended to legally marry sooner or later. A key issue in how the wedding is planned and the potential gap between the religious and legal ceremonies is the process of getting to know each other. So for some participants, the extent of their engagement with each other prior to the nikah was just in meeting in public, perhaps with family present. Those customs and norms meant that they could only actually begin to get to know each other after a nikah took place. So for these couples, they're still figuring things out, and the nikah essentially enables them to do this. And in this situation, when they have the ceremony, they don't necessarily move in together immediately. So that's one sort of category of participant. For others, there was more of the getting to know before the nikah was planned. And in that situation, they were probably more willing to enter a legally binding marriage much closer to the nikah ceremony. So law reform needs to provide ease for those wishing to combine their ceremonies, while also remaining flexible for those who actually do not want to do that. It's likely that those who marry legally and religiously close together will benefit from reform proposals that enable combined ceremonies. It's not really clear how those reforms will impact on those couples who would otherwise have a larger gap, who may still opt for dual ceremonies should reform occur, as the Law Commission proposes. This also highlights the potential impact of removing the option of a religious-only marriage, which has been proposed in some sectors. Because what that quite possibly does, it removes the ability of a couple to figure out if they're right for each other, and instead it launches them straight into a legally binding marriage, perhaps prematurely. And this may be premature because of their age, if they're very young, or due to the point in their relationship where they've not really gotten to know each other yet. Consequently, there may, of course, be a rise in divorce rates. The second point on the slide relates to what's the meaning of the nikah? And for the vast majority of the participants, it was the nikah first, as the priority is the nikah as the real wedding. And this essentially means that that is the ceremony that, as far as a couple are concerned, mean that they are married in the eyes of God. Now, another thing to note here is this didn't necessarily negate the meaning attached to the civil ceremony, but it does indicate the civil ceremony serves a different purpose, which is, of course, legal recognition. So if this is the role of that ceremony, a simplified ceremony makes a lot more sense. The third point on the slide, which is, I can't possibly speak about this without talking about the reasons for couples remaining in non-legally binding marriages. And within our sample of participants, a legally binding ceremony was usually intended. So for the majority of them, they intended to have a legally binding ceremony at some point. It may not occur at the same time as the religious wedding. However, for the majority, it was on the horizon. Very few had no intention to legally marry. And of those, they tended to have had previous experience of being legally married or being in a religious-only marriage, and they decided that they preferred a non-legally binding option for a range of different reasons. One of those being the complexity of the civil divorce, and also in another case, wanting to protect their financial position. And in that example, it was a young woman who was in her 20s who had married before she had a son, and her considerations related to finances and her child. Another point to note is actually we found that women were just as likely as men to not want a legally binding ceremony, certainly from our group of participants. So those are the more thought out positions. There were some participants who delayed the legal wedding for no particular reason, other than citing that life simply got in the way. And again, this speaks to the need for a simplified process of marrying, which enables them to do both ceremonies at the same time, because for them, there was no particular reason why they hadn't had the legal marriage yet. There are also those who suggested that it might be easier to exit a religious marriage because this would only require reference to a Sharia council or other similar body. Of course, this assumes that both parties in the couple want the divorce. And as we know from the extent of research on Sharia councils, where the male partner refuses to grant the divorce, actually this process is not that simple and straightforward. The final point there, young people. So while the majority of our participants were over the age of 30, some suggested that younger couples are more likely to have a religious-only wedding, as the legalities would simply not be a priority for them, which is perhaps reflective of their peer group relationship norms as far as legal marriages are concerned. So the final question here leads nicely on from that. Is a legally binding wedding in everybody's interests? The answer to that from our participants was not always. It will have benefited some of the participants, including just the only participant who potentially was deceived in the promise of a legal wedding by her ex-husband at that stage. But for others who had gone through a civil divorce, for example, actually they didn't view that as an experience that they wanted to repeat. So it certainly seemed to be the case that where there are no children and no assets, arguments for legally binding marriages lose conviction. So in conclusion, a simpler process was welcomed by our participants, both the individuals and the imams and those conducting the ceremonies. However, as the proposals mean that formalities will still have to be adhered to, it may mean that couples still have a nikah first for the relative simplicity and ease of planning and entering into a nikah, and still have a dual ceremony. I'm so sorry, my daughter is singing very loudly in the background, and I do apologize if that's coming through.
I can't hear her. Sorry, I can't hear her.
Thank you. That's everything, Nazia.
Just to pick up on a point really, Rajnaara, and that's something that's really interesting that you said, which is that you found that there were a number of Muslim women not wanting a recognised marriage. And I say that because when you look at the wider discussion, there's a lot of, and quite rightly, emphasis on protecting vulnerable Muslim women, and there's an emphasis of having recognised marriages. But I find it interesting you mentioned that, because my experience is I've come across a number of Muslim women who are in a better position not having a recognised marriage because of wealth that's arrived, or they've got wealth for some reason and they wish to protect that and not have a recognised marriage. So I'm very pleased that you found that as well. Thank you.
Yes, and it was a theme not just from the female participants. The imams also mentioned this, that they had seen an increase in women making decisions around financial considerations when it came to the weddings.
Good, lovely, thank you. If I can now move on to Graeme and ask Graeme to speak about the key concerns that he has found or can share with us for the Jewish community.
Good evening, Nazia, and if we could go to the slide straight away. I'm going to get into some technical stuff very quickly with the limited time, and having a look at some key concerns that exist at the moment. Right up until April of this year, the process was that a Jewish marriage secretary would certify that the marriage had taken place according to the usage of the Jews on the register, and I'll come back to the usage of Jews and what that means in a moment. What has happened this year is that there is a schedule that has replaced the use of registers, and that does not enable confirmation of the validity of the marriage according to the usage of the Jews. And therefore, the general feeling that should be amended as that's required. One of the other central issues at the moment is that previously the marriage return had to be sent to the district in which the synagogue was registered. But now it needs to be returned to the registration district where the marriage took place, and regulations state that it should be returned by hand if possible. Now, those regulations are somewhat problematic, and the concern is that it should actually be returned to the registration district of the synagogue, which has been responsible for the wedding, wherever the wedding has taken place, and that would enable the registrar to keep a much better check on what's going on. And the idea of that is to prevent forced marriages or sham marriages and so forth. So those are just sort of a bit of troubleshooting that I've done with one of my colleagues who actually is a marriage secretary, as well as a very well-known lawyer. And the other aspect, just to point out, just to start off with, is that there are some ultra-Orthodox communities who may not actually bother with the appointment of celebrants, because they consider that only Jewish law is binding upon them. And that is a problem which I don't believe is going to necessarily be resolved by the Law Commission proposal. So I'm simply troubleshooting some of the elements here just to start off with. If we could go to the next slide, please. The reason I brought that slide up is because in the preparation, Nazia asked me to have a look at this from the perspective as a practicing lawyer based in North London. And I practice, and I also live in the London Borough of Barnet, which has a very sizable Jewish population and has the highest density of Jews within an area within the UK. One thing I do say about the Jewish faith is, particularly if you're acting for Jewish clients, is it really is a question of know your client, because there are very many different strands of Judaism, and the denominations that I think most people would probably be familiar with are in the Orthodox strand, which is the United Synagogue, the Federation of Synagogues and Independents, who follow the Beth Din. But then there's the strictly Orthodox, which is the much more religious aspect. Some of those are ultra Orthodox. And then there are other denominations, including Reform, Liberal, Masorti that's come through in recent years, and Sephardi. And looking at that, I'm actually very surprised that there's so few Sephardi Jews left, according to that, because it's quite important traditionally. One thing to be aware of is that in terms of the evolution of the law, it was originally, marriage secretaries were originally authorised back in 1836. Reform synagogues obtained authority in 1856, and liberal synagogues got authorised back in 1959. There is some modern day issues even now, which is that the West London synagogue may be breaking away from the Reform synagogue. So the situation is ever changing. Just be really aware of who you're acting for and what they're doing. And I say that from experience and acting for many people from many communities. And the situation, as I've described on that slide, is that ultra-Orthodox communities may not accept the authority. So be aware of that. If we could go to the next slide, please. So a key point is, how do you recognise the usages of the Jews? And essentially, there are three elements. There are three key elements that form part of the ketubah. The ketubah is the Hebrew marriage contract, which should be present, and it's read out at a Jewish wedding ceremony. And the requirements of that include the promise to marry, which is the most important thing, the giving of rings, which is by a man to a woman only, and the third element, which I'll say it, but it's by implication in the ceremony, is the need for sexual intercourse. The thing that probably a lot of people are familiar with in Western culture, probably from watching Hollywood films and so forth, is the breaking of the glass. And that's something in terms of, in the Jewish religion, there's a lot of powerful symbolism, and that's a very powerful symbol. And that, I think, is the moment when the guests believe that's the marriage celebrated. In fact, it's a tradition and not a requirement. So, I mean, there are also various aspects to how these marriages are celebrated and how that's done. In traditional Judaism, there used to be two ceremonies. The engagement or erusin would be some while before the marriage, the nizurin. Now they are completing the same ceremony. So it's quite nuanced. There's quite a lot going on. One of the other points to raise there is that it would be problematic to insist in the Jewish religion that all religious organizations should celebrate same-sex marriages if it were to be imposed against those communities who regard this against their version of religion. And the reason I say that is because there is a clear distinction between what is accepted from synagogue to synagogue. Orthodox synagogues do not authorize or allow marriages to take place between the same-sex couple, whereas Reform and liberal synagogues clearly do. I think there's one more slide. So the other point I was just going to say, also from a practitioner point of view, in terms of know your client, really be aware and be sure that they've actually got married. Just anecdotally, I've had situations where people say they're getting married and they're not getting married. An example of that might be a rabbi attending a meal. That's not a wedding, and it's actually quite similar to the Akhtar and the facts of Akhtar and Calm. And it comes up and it's cropped up in my practice. The other aspect which is important is the interplay between England and Israel. Many English Jews go to live in Israel, and many Israeli Jews come to live in England. In terms of the community, there's quite a lot of movement. Jewish people have always moved around. It's fair to say we're sort of wandering minstrels, as it were. The concern in the modern day in terms of international cross-border implications are, is a marriage that's taking place overseas, is that actually going to be recognised because it wasn't recognised as valid in the country where it took place when they returned to England? And are they using that as basically an opportunity to get their marriage upheld? And the reason we say that is because a large number of Jewish weddings are not considered to be Jewish marriages in the state of Israel unless they are religious marriages. Now, in order for a Jewish wedding to be valid in Israel, it must be a religious marriage because it's religious law that operates in Israel. Although Israel is actually a largely secular country, there is a wide understanding and acceptance that it's the religious law that applies. And that is a very important nuance to be aware of as an English practitioner, because that is something that goes on quite a lot and you need to be aware of that. And actually, I find it's, my experience as a practitioner is just really be aware about the marriage formalities requirement, because I think we get a lot of our learning and a lot of our practice is based on the breakdown as opposed to the formation. So those are my observations, Nazia.
Thank you, Graeme. Thank you for that. We can now turn to David Hodson and speak about the Christian community, if I can describe it as a Christian community. And David, I often hear, and I say rightly or wrongly, that all Christian marriage ceremonies are automatically recognised because Christians, like Jewish and Quaker couples, for different reasons enjoy a special status when it comes to weddings law, which, if that is the case, without going to the correctness of that view, has to be for historical reasons. And this also reminds me of the case of, if I pronounce it correctly, Jarais and Yaqub back in 1997, which involved Coptic Orthodox Christians who married in an unregistered church by a priest who was not authorised to solemnise marriages and where no notice had been given. And the court made a finding of a void marriage, not a valid marriage, which just illustrates the point that not all Christian marriages are automatically recognised. So if I could just ask you to share some views of the Christian communities and when it comes their view when it comes to marriage and weddings, please.
Nazia, thank you very much. Thank you hugely for holding this panel, which is a very, very exciting opportunity. Start a little with my background. I became a Christian in my late teens, most important element undoubtedly in my life. I started in a nonconformist background. I would now be low Anglican, and there are differences, as you say, in that regard. I've been involved in a number of Christian organisations concerned with parliamentary reforms in various ways over the law, whether family law and otherwise. I think part of the problem, I think we all suffer from this in faith communities, there is no one position. Trying to find anything that the Church of England has produced on this subject is jolly hard. So I can only speak from my position where I would be coming from, but I would hope I would speak faithfully for where many other Christians would be, particularly I would have thought on the evangelical wing. I have to concede immediately the Anglican aspect of the Church of England has had favourable treatment over centuries. Elizabeth brought attention to that in her opening part. It's throughout the Law Commission paper. I don't think there would be many in the Christian community, there would be some, many who would argue for this to continue. It simply can't. It can't in a pluralistic society have this to happen. There are parts of the Christian church which do not have the favourable treatment of the Anglican church. The Christian community hasn't had a problem with the marriage wedding laws that other faith communities have had. We've had an easy time of it in that respect. So where are our concerns? I think our concerns would be about marriage, which flows directly from weddings. And it is this where I think many Christians would want to get involved. If I could go to the next slide, please. And part of the difficulty is working out the position of what is a Christian wedding, because it is so tied up with English society, English history. And without embarrassing Rebecca, she has written on this often looking at the history over the years. It's a real challenge. What is the Christian essence of a wedding to try and divert it away from what is the historical background? And many Christians would believe that marriage is a creation ordinance given by God for the benefit of everyone, given we find that in the first few chapters of Genesis. And although Christians would therefore believe there's a distinctive blessing for a Christian marriage, they would believe that there's a blessing, something special that occurs when a couple get married, the idea of a blessing to the married couple, whether they're of any faith or none. So what are some of these constituent elements? Well, I tried to set them out on the slide. Some of them are more controversial than others. But I think for these purposes, for the Law Commission's purposes, one of them would be that it is public. It isn't a private act between two people behind closed doors that nobody should ever know about. It is public. It's public because it's family, it's public, it's community, it's public because it has status. And these are elements that I think many Christians would bring to the party when we're actually looking at these proposals. It seems to me they inform quite a lot of where the Christian community would be wanting to support sympathetically the Law Commission's proposals, but then make a few comments. So if I can go to the next slide and just set out a few of the areas where, subject to that caveat that many Christians would want to support what the Law Commission is doing in their proposals, really timely, important, well overdue, where might they be? One of them is pre-wedding information and education. The research, such as it is, shows that the pre-wedding information will help the first 5 to 7 years of married life. After that, it all tails away and who knows what's going to then happen. But in the first 5 to 7 years, it will be of considerable benefit. And a lot of this is already going on primarily from the faith communities across the country. About 20 years ago, the Home Office called a meeting of all involved in pre-marriage education. I think there's about 150 of us turned up, etc. And towards the end, they said, out of interest, how many of you are involved in faith-based communities? And almost all were. That's certainly not to say that it's not going on outside that. And so I think the faith communities have done a huge amount and are still doing a huge amount with it. But there's a restriction on what registrars can tell the people when they get married, a restriction in law, and some of that is right. There ought to be a carefulness there. But we'd like to see a greater opportunity for pre-marriage education, training, for giving notice, giving information about local courses at the time when people actually apply for registration. Remove some of the restrictions in law and registrars. Secondly, public notice. In the Church of England, we have bans. They are historic, they are chronic, they have no further place in a future 21st century wedding law. And I and many would want to get rid of it. Some in the Church of England want to hold on to it, but it has to go. It is simply just not serving the purpose. The next one is more important. If the location is no longer public, as I understand is going to be proposed, what else will not be publicly known? And I think this is where, with the support, the questions are going to be asked. What do we know, particularly if we're going to have it in public, in homes, in places where we won't want the mass of the public to come? How much should we know if we are going to have 2 celebrities get married? If they get married in the Chelsea Registry Office, anyone can turn up if there's room, etc. How much should be public? And if it's not public, what are we then saying about the relationship between this process of wedding and the status of within society? The next one again has been raised, and again it has some controversy. At which point in the ceremony are they married? And both Graeme and Rajnaara have actually spoken about some of the issues about when does it actually occur. Is it possible to say during a wedding ceremony, now they have done the deed, now they are man and wife, or husband and husband, wife and wife, or whatever it may be? And I know, and discuss this with the Law Commission, I know there are comebacks on that, that there are some difficulties, but how much should we actually be putting into that? Should there be specific recognizable words for those attending to say, now it has occurred? When does it occur? Another issue, chapter 10 of the report, the most complex of all, regarding nullity, voidable marriages. And this is where the issues of the non-qualifying ceremony have tried to be, I would call, shoehorned into our existing law of nullity. And I don't think it works. Respectfully disagree with the Law Commission's proposals in this. The law of nullity is old-fashioned. If we were going to create a law, nobody would include the law of nullity now as it is. So we're trying to push it in there. And I don't think that works. I think we've got to find a better way of helping those who have been deceived into getting married, not actually be within a civil marriage. I don't think the law of nullity works. Last 2 remarks. I think many within the Christian community would want to make sure cohabitation, whether a reform of the law or otherwise, is not confused with marriage. The Law Commission produced some excellent proposals, I'd say 5 years ago, but I suspect time flies, it was nearer 10 years ago. I think they were excellent proposals, and they put in place a distinguishing with the law of marriage, particularly the financial outcomes. And I would like to see us going back to that if we are going to have law reform. But I think most of all, the last bullet point I'd want is to say that many in the Christian community are troubled at how many do not get married for a long time. They feel they can't afford it. The average cost of a wedding is 15,000. Gosh, that's far too much. How can we make it simpler? How can we make the process easier? How can we make the registration easier? How can we encourage more who might otherwise cohabit or might other be saying, shall we, shan't we, etc.? How can we encourage more to get married? And I think this is where many in the Christian community would be coming from. We think, if I may say, Rebecca, Elizabeth, personalizing it, you've done a brilliant job in your report. We would want many of the reforms to come forward. The distinctive position of the Anglican Church can't be sustained, although we must continue to have religious marriages of one form or another. But there's just a few areas around the side that I think we would want to be looked at again, and I'm sure you'll do so. Nazia, thank you very much indeed.
Thank you, David. And there's a number of questions that David's put there to both Elizabeth and Rebecca, and we'll see whether they'll be answered today. But I mean, just generally, what I've been taking from the main faiths that we focused on today. So for the Christian faith of the Christian church, the concern will be in relation to encouraging marriage and not to confuse cohabitation marriage, is one of the key points I've heard from David. And for the Jewish communities, Graeme, if I've heard correctly, is in relation to the concern for the Jewish community is not so much the legal status, but in terms of the actual process. And you may have a civil marriage, but will that be accepted for the religious authorities, whether it's in Israel or here, which is quite a distinct point from, say, the Muslim communities, which Rajnaara, I would consider the issue of legal status is a concern for us. And the other issue, which I think you've made the point of, which ceremony holds more weight to the couple before they might live together as husband and wife, is it the nikah or the civil marriage? And the reason why there might be a gap between the two. If I can now turn to Elizabeth and Rebecca, and I have to say, I repeat what David has said, I think you've done a marvellous job trying to capture all various scenarios to try and allow someone to petition, to allow financial provision. And just for members of the audience, if you ever get time, if you look at paragraph 10.127 of the Commission's report, there's a wonderful table, and I'll just quickly show it to you. It's a wonderful table there, setting up all the various scenarios that could take place, which could then result in either a valid, voidable, or non-qualifying ceremony marriage. So if you have time, have a look at that, and you'll really see how hard I think the Commission's gone to try and capture as many scenarios as possible. So if I can hand it over to both of you, please.
Thank you, Nazia, and thank you to Rajnaara, Graeme and David for their really helpful comments and insights into different practices in different religious communities. I'm going to focus here on how we think the Law Commission's scheme would help couples to have a wedding ceremony that reflects their beliefs in a place that's meaningful to them and suitable for weddings, and for that ceremony to be recognised by law. Lots of points raised in the previous presentations. Hopefully we'll get a chance to pick up on those and some of the questions. So this infographic comes from the consultation paper, and we've sort of pulled out some of the key aspects which we think are particularly relevant to the discussion today. So the Law Commission's proposed scheme focuses regulation on the officiant rather than on the building where the wedding is to take place. And this will give greater freedom as to where weddings could be conducted. So under our proposals, weddings will be legally permitted to take place anywhere, including outdoors or in a private venue such as a home or on a military site, and on inland, coastal and territorial waters. For a wedding to take place in a given location, the officiant would have to agree, and the officiant would be responsible also for considering the dignity and safety of the venue. Now, this would increase choice for couples, allowing them to get married in the location that was most meaningful to them. And that would also open up lower cost options. So David flagged up the high cost of weddings at the moment, but getting married at home or in small community venues would mean not having to pay the sort of often considerable sums for approved premises. Now, religious groups and, if enabled by government to conduct weddings, non-religious belief organisations would be entitled to insist on their own requirements about where a wedding is to take place. So if an imam felt that actually he only wanted to conduct a nikah in the mosque, then he and his group would be entitled to say that to the couple, rather than the couple insisting that the wedding should take place in the place of their choosing. But equally, religious groups would be able to choose to conduct weddings in a wide range of places. We understand that at present, some are conducting religious-only ceremonies on approved premises as a separate to the legal wedding. They'd be able to do so under our scheme in gardens, in restaurants, perhaps in a village hall. The Nuffield project that Rajnaara and I have been working on found that was quite a popular venue for non-legally binding ceremonies because they were cheap and very much rooted in the community. So it'd be up to each group as to what was deemed appropriate according to their beliefs. Now, the core requirement for wedding ceremonies under the Law Commission scheme would be for each of the couple to express their consent to be married in the presence of each other, the officiant, and 2 witnesses. There'd be no requirement for them to express consent in a particular way, and consent could be expressed non-orally. And this would accommodate the many ways in which people show their consent to be married. Again, there is a real issue with the prescribed words, and that's an issue that is different for Christian and non-Christian communities, because the prescribed words come from a Christian tradition. They are effectively a direct lift from the Book of Common Prayer. So it was very easy for Christian communities to incorporate those prescribed words into their wedding ceremonies, because most of them had wedding ceremonies that were modelled on the Book of Common Prayer to start with. So you don't see the join in a Christian ceremony between the prescribed words and the religious ceremony. But in a non-Christian religious ceremony, the prescribed words are normally said separately and experienced as a separate civil ceremony, not a means of recognising a religious ceremony. And again, as with venue, religious groups and, if enabled to conduct weddings, non-religious belief organisations could impose their own requirements about the ceremonies that they conduct, including whose weddings they will conduct, picking up on Graeme's point about same-sex weddings and the content of those ceremonies. But it wouldn't be a criterion of legal validity that the ceremony was conducted in accordance with particular religious rites. It would be the expression of consent that was the important factor. Next slide, please, Nazia.
I'll try and get that to work. It's not moving to the next slide.
Thank you.
Oh, yeah, sorry. Yes.
Good. So this is actually an alternative to the table that Nazia mentioned at paragraph 10.127 in the report, a different sort of way of conceptualising the proposals on validity. We propose to clarify the rules governing when a wedding would be classified as void or non-qualifying, aiming to give more legal protection to couples. So ideally, of course, we would make it easier for couples to have a legal wedding and the outcome would be a valid marriage. The next best thing would be for the ceremony to be classified as void, to at least give the parties access to the remedies available under the Matrimonial Causes Act. And under our scheme, as long as the couple either gave notice of the intended marriage, or at least one of them believed that the ceremony was being officiated by an authorised officiant, the marriage would be void rather than non-qualifying. If they hadn't given notice and neither of them believed the officiant to be authorised, then it would be a non-qualifying ceremony. So there would remain the possibility under our scheme for a couple who know that they don't want a legal ceremony at this particular point to have a ceremony without attracting legal consequences. I think the next slide has questions for all of us, but I think the first one is for us, if you want me to carry on, Nazia.
And just very brief, just because of time, are there suggested areas of reform which you anticipate would not be welcomed by certain organisations or individuals?
So obviously in the consultation paper, we've tried to propose a new scheme that would work for everyone to ensure that the law is sufficiently flexible to recognise the many different ways that marriages are celebrated in England and Wales, but still ensuring that there's adequate protection of the state's interest, including in preventing marriages for the parties who are not eligible to marry, and to protect against forced and sham marriages. And a large part of our proposals are about strengthening civil preliminaries, about how notice is given to ensure that there is public notice that the wedding is taking place. And of course, we appreciate that the reforms we've proposed may not be welcomed by some groups for whom the current law works well. And it may be that some groups feel that we haven't struck the right balance, that some might feel it gives too many freedoms and some might feel that there's still too many restrictions. But I'd be happy to hear and respond to questions on that.
Thank you. And I just really, if I can just move on to the next section, just really for time purposes. So just very briefly, this is to anyone who might want to answer these questions very quickly. What do you think could assist various communities and their members to question the legal status of an intended ceremony? Anyone want to answer that?
Nazia, I guess I can come in on that. I think I'd answer with a question. So you've posed a question around the communities questioning the legal status, and really the focus should be on the couple and on their families, because quite often communities, they'll attend weddings, but they won't feel responsible for holding anyone to account if they feel something is happening in a way that perhaps it shouldn't be. Within our research, we did find that families do play a role. So they play a role either in terms of them being involved within the ceremony itself, or in advising a couple to or not to legally enter into a legally binding ceremony. The majority seem to have been encouraging couples who weren't in a legally binding ceremony to do so, but at least in one case, there was a family that was opposed to it. And so I think really the question usually comes to the couple and about legal awareness and about empowering them to make those decisions. So I'm not sure whether the communities necessarily play a role there.
But just on that point, for example, so for those who are conducting marriages in various communities, whether there's going to be more pressure known as to for them to fully understand the legal consequence of the ceremony they're about to conduct and provide the sufficient information in good time to the couple who intend to marry in terms of what the legal status will be. So I do wonder whether there is a need for awareness campaigns by leaders in various communities to really illustrate the point as to what would be the case if a marriage was recognised or not. So there are these informed decisions.
I will very quickly answer that before I let somebody else come in. I think certainly, again, within our data, we found that the majority of those conducting ceremonies from the majority of the communities we engage with do give that advice, and it's the right advice. There are, however, a small cluster who don't feel that it's their place to advise. They're there just to perform a ceremony that is maybe religious in nature. But on the whole, that responsibility seems to be one that those conducting the ceremonies do feel already.
And I suppose in a way you have then in turn also answered my second question, which is what's required for buy-in at the Probert levels for reform. And I was wondering there in terms of significant members of communities in understanding what the reforms will be. And it's your position, which is that you have found that the leaders do make that distinction and provide the relevant information.
At the moment, yes, but I think that's a separate question to the proposed reforms and whether there's awareness of those and whether there's buy-in. We've certainly had a lot of questions around what those reforms would mean for the status of that wedding. Certainly within the Muslim communities, the imams generally are not authorised persons, so they're not performing legally binding ceremonies. And so I think there's a massive question mark against whether or not they will then become officiants under a new scheme. So we still definitely have an issue there.
Thank you. And if I could just turn to the last question, if somebody else would like to come in, which is, are there any sensitive issues that require addressing head on? And if so, how? And if I just to say, the sort of points that come to my mind are things like polygamous religious marriages. So there are polygamous religious marriages that are taking place. And I suppose with the reforms that they were implemented, they can continue and what impact that could have, especially on vulnerable women and children. If somebody might want to say something on this. think that's a no. I suppose that one of my main points and concern here is that there is this real worry that, and has been, that there are polygamous marriages taking place, religious polygamous marriages, I must say here, and people don't know that they're entering into a polygamous marriage and the impact that can have. And when that relationship breaks down, the recourse they can have in terms of financial remedies, which I know we will touch upon.
Nazia, I was just going to pick up, it's on the chat, it's actually from my colleague Peter Martin, and it's really about awareness, maybe a slightly sensitive issue for Face, but it's maybe the requirement to interview the couple and that they get advice about the nature of the ceremony, so the couple appreciate the effects of what they're doing. So it's about awareness and education at the same time, so people understand what they're doing. It's just, I know the bar is very low for marriage. Learned that in my degree, but I mean, it's about people knowing what they're entering into.
I'm glad you said that, Graeme. I was just about to say exactly the same thing, and I thought Peter Martin's contribution was hugely helpful. There is a huge burden, I believe, on the celebrants under this new process. We have a celebrant profession in this country at the moment, but I don't think they realise what's coming down the tracks any day soon when these reforms come through. A huge burden on them to make sure there is good information passed on. Now, some will do it better than others, as the nature. But Graeme, I totally agree with you and Peter. The information has got to be passed on, and it has got to say what you are doing is entering into a legal ceremony, and they must know that is the consequence in law and some of the consequences that go with it. I think that's vital, and it does trouble me that there will be all these ceremonies are still occurring even after we've opened this up. With all this relaxation, rightly opening up with a relaxation, there still seems to be suggested there will be lots of ceremonies going on around the country of people where one or both are knowingly not engaging in a civil wedding. It's I think it's I would very much hope that the problem will be far reduced once these proposals go through.
Could I sort of come in on one
Please.
point in terms of sort of who the onus is going to be on to provide information? Because of course our scheme envisages that couples will be giving notice, engaging in preliminaries before the wedding, and certainly for non-Anglican, well, obviously we asked a question about Anglican preliminaries in the paper, everybody would be having an interview with a registration officer. So not be the individual celebrants who are always necessarily being tasked with passing on information about the legal effect of the ceremony.
Thank you, Rebecca. Thank you for that. If I can move on to the fourth part of today's session, which is about other areas of law, and this specifically in relation to relationship status arising from the breakdown of an intimate relationship. Are there other areas of law which could require or could be helpful if they were reformed? So my first question really goes to David, and it's really about cherishing informed autonomy and knowing that as part of the proposed reforms, non-qualifying ceremony marriage can take place. So if this continues, David, what are the legal remedies that currently exist when a non-qualifying ceremony marriage breaks down with or without children?
This is where the courts have been very busy over the last decade sorting out in England and more often marriages and divorce that occur abroad. Was it a formal marriage that should be accepted according to law? And there are a number of cases, they're now called non-qualifying, non-marriage cases. And if they are declared a void, then you can still have financial provision. If they are declared a non-marriage, there is no financial provision. I'm sorry, guys, this is all about the money. This is not about, I've got a piece of paper called a divorce petition, or I haven't got a piece of paper because I was never married. This is all about financial claims. And this is why the element of the nullity is such a heavy one that carries such a heavy responsibility. Well, of course, there are other elements. If they have got children, then there's Schedule 1 of the Children Act that could apply. There might be Talata, but that is a very difficult claim to bring. At the moment, the cohabitation provision is very, very meager. And that's why we are all sympathetic to people who enter into what they believe is a civil wedding, then finding out 5, 10, 25 years down the line, oh, I've never actually been married. how do we deal with it? I personally don't think we deal with it by trying to bring all of these ceremonies into some form of sort of nullity of divorce. I think we've got to find a remedy which is based on somebody having been deceived. Because let's call it out for what it is. Somebody has been deceived by either the other spouse or with others into believing they're in a civil marriage. I really worry that with some of these proposals that we are going to have a lot of litigation where one person says, we both knew it was not a civil wedding, and then the other one says, I thought it was. And how 5, 15, 25 years down the line are we going to gather the evidence to find out which of them was actually right? And I suspect the courts are going to be sympathetic to the more vulnerable party and find in their favour. We saw David Williams' decision where he tried to do just that and rebounded on appeal.
So
That's why.
but if you just focus on how things currently stand, if we
Yes.
may. So turning me to Graeme, knowing, and then David's touched upon, I suppose slightly answered your question, which is, do these remedies provide fair outcomes? And I know that David used the word talata and Schedule 1, which we collectively use as cohabitation. So I'll let you answer both questions there.
Right. I can answer this question in many ways, and I could take a long time answering it, but I'm going to answer it concisely because of the constraints of time. The short answer to your question is no. And the reason why they don't provide fair outcomes, and David's touched on Schedule 1 and talata, is because there is no recognition essentially in the remedies that exist that are not family law based remedies specifically at all for the gender related disadvantage that applies as a result of non-earning or childcare contributions which do not receive any recognition in terms of cohabitation in English law. And the contrast, and the stark contrast, is that non-discrimination has been a key feature of financial remedies on divorce for over 20 years, since the case of White and White, and also further explained in Miller-McFarlane. And that was only possible because of the statutory checklist that was introduced, giving the court a much wider discretion under Section 25 of the Matrimony Causes Act 1973. That's a nutshell answer.
Thank you for that. And I suppose one of the points that I've come across a lot recently is there any prospect for those in non-qualifying ceremony who have those status to enjoy a distinct legal status enabling fairer outcomes? And I did a bit of research recently on breach of promise, which is a right of action which is abolished in this country, and whether that was reactivated or reintroduced in some revised form, would that assist? So it's really an open discussion to the panel in terms of, is there any prospect for there being that distinct legal status? Because those who in a non-qualifying ceremony have had some form of ceremony which they believe has brought them together as a married couple, whereas those who are just cohabiting outside of any ceremony are not in that state, not in that category.
Well, unless it's statute law, we're in the hands of the courts of equity, of what is fairness, to try and find equitable principles to come to the aid of somebody who, I use the word deceived, somebody who entered into a ceremony believing it was one thing, having been given representation, presumably by others, that it was a particular civil ceremony, and then discovers actually, no, it wasn't. I would have thought it's there, but I mean, Graeme has pointed out already, we've tried equitable principles and sometimes they work and sometimes they're inadequate. But it really would seem to be an instrument of equity to come to the aid of people in that situation rather than any other provision.
I think it's sorry, David. I think it's difficult to talk about giving status to a non-qualifying ceremony, but I think we can talk about remedies that might be appropriate.
I agree.
In that situation.
I agree.
But I think I come back to the point, and obviously Rebecca's sort of answered that in part, but I do feel that if the celebrant actually explained to the couple the consequences, the legal consequences, and did that, then presumably that makes it less likely it's going to be a non-qualifying ceremony.
But Graeme, the problem is it not that there won't be a celebrant there, but the person going through the ceremony is with, let's presume it's in a faith-based community, is with somebody from their faith-based community who doesn't say, maybe they don't feel an obligation to say. We have stories of people who go to a hotel and on the outside of the hotel it says registered, hotel registered to conduct weddings. And we hear stories of people saying, well, therefore I presume that whatever I did within that hotel, which seemed like a wedding, was therefore a civil wedding. And no, it wasn't. There's, I think, Graeme, that's where I would find the problem, is that if there's a celebrant there, coupled with the registrar's information that Rebecca referred to when they give the registration, I'm comfortable. The problem will lie down the line where the celebrant isn't there, and yet nevertheless somebody thinks, gosh, what I'm going through looks like, feels like, seems to be on television like a wedding ceremony.
Yeah, I'd agree with that.
So under the Commission's proposals, there would have to be somebody at least purporting to be an authorised officiant in order for it to get into the void category. If you had a couple who were just exchanging consent with the two of them, then that would be a non-qualifying ceremony.
Thank you.
Thank you. We're doing very good for time, so I just go to the last section for today, and that's in relation to the questions that we were asked in advance. And again, for some reason, my screen is.
Oh, just Nazia, you haven't asked the question specifically, but I am going to say that you do also need cohabitation law reform. The view actually of resolution is that we did answer the paper. But actually you do need cohabitation law reform in its own right in order to deal with the inequalities that exist. And that's a specific piece of legislation. So I just wanted to footnote what I'd said earlier.
Yeah, and I completely agree. And I find that when we talk about the non-recognised marriage cases, non-qualifying ceremony cases, we tend to fall into the area of law which concerns cohabitation. But again, quite rightly, we shouldn't confuse the two. They're very distinct areas. Cohabitation, marriage are very distinct areas. If I can just turn to questions that we received in advance of today's session. So the first question, this is again open to the panel, and hopefully people actively wish to answer. So the first question is, would the reforms for Islamic nikah marriages be retrospective in nature, so that any couple married in the UK could easily have a procedure to initiate a civil registration outside of the existing procedure? Probably more of a question to someone from the Commission.
So I think it's difficult to see how reforms could be retrospective, because, as I said, under our schemes, couple would be giving notice in advance of the ceremony and then be issued with a schedule authorising the marriage to go ahead. And I think we also need to move away from talking about registration of marriages. So some people use registration to refer to the whole process of getting married, and some use registration just to refer to the process of recording the marriage after it's taken place. And it's not always clear which is meant. And of course, registration in the second sense doesn't confer any, you can't register something that hasn't taken place in accordance with the Marriage Act 1949.
I'm very glad you said that, and I think that's absolutely right to emphasise that point. So the second question is, if a proposed form of registering a nikah involves rewriting the Sharia, and here is in relation to the marriage being monogamous, then this is not acceptable. If the proposals allow for a nikah certificate to be registered, then the law of bigamy must change. Again, any comments to this?
So the Law Commission's project is about how couples can marry, not about capacity to marry. So capacity in the law relating to bigamy lies outside the scope of our project. So I think it's important to recognise that these things are distinct. So, I mean, English law has recognised Jewish forms of marriage since the 18th century, but has never applied special rules to Jewish couples when it comes to capacity to marry.
Thank you. The third question is, the new petition registered by the Muslim Women's Advisory Council recognised the nikah as a legal form of marriage to prevent, recognise the nikah as a legal form of marriage, and that is to prevent lack of official marital status. And this is because many women are left homeless and struggle financially. Any comments to this question?
I can just come in there, Nazia. I think there definitely needs to be a solution for women who find themselves in that position. And obviously we need to note that it isn't just Muslim women in nikah marriages that can potentially be here. It's all of the cohabiting couples where similarly there aren't those financial remedies available. And in my research, certainly I've looked more to the revision of cohabitants' rights in order to find a solution here, because the problem with having a blanket legal recognition of the nikah marriage is that there are lots and lots of different couples who are choosing the religious only marriage for a range of different motives. And they would then all be captured here too. And so you'll end up in a situation where in order to solve a problem for one quarter of the community, problems are created in other areas. So I do believe that, yes, a solution is needed, but perhaps this isn't the solution.
Can I break in? If these proposals come through, do you have any feel for what percentage of the present marriages which are not according to civil law in the Islamic community would still be in that category, and what a percentage of those would now happily embrace the new Law Commission proposals? In other words, what sort of problem have we got, so to speak? I say that respectfully. What sort of problem have we got further down the line, even if these proposals are brought in?
Mm-hmm. So,
excuse me, Nazia, asking the question.
No, absolutely fine. Go ahead.
Yeah. So I guess the first thing to say is we don't have the statistics because it is very much a hidden
Yes.
thing. We don't know how many couples are in non-legally binding marriages. The indications from our study are that those who want to be in a legally binding ceremony and who enter that ceremony very close to the nikah are probably going to be the ones who benefit from this reform. So they're the ones who are more than likely to jump on this and say, yep, let's just get it all done in one fell swoop. But there are those who I outlined in my presentation earlier who don't want that recognition yet. And that is the majority of those who don't enter into the legally binding ceremony in close proximity to the nikah. I guess the key thing there is it's the yet part. So for whatever reason, there's a period of time during which they're happy to be within a non-legally binding ceremony, and then they will take those steps later on. Then there is that cohort who do not want to be in a legally binding ceremony, and they will stay outside of the provisions, come what may.
I'll just quickly move on to the last two questions because we're running over time now. So hopefully the next two questions can be answered maybe by yes or no very shortly. So the fourth question is, must you have a civil marriage at the same time or before your religious marriage? And I suppose this is in relation to the reforms that are being proposed.
So the reforms would preserve the possibility of having a religious only ceremony and would not be making it a requirement to have a civil marriage first.
Thank you. And the last question is, will an imam who conducts a nikah without a prior civil marriage be committed a criminal offence?
So under our scheme, we're not looking at the issue that was raised in the independent review into Sharia law as to whether it should be a criminal offence to conduct a religious only marriage. But we are looking into offences that might support what we've put forward. And we've provisionally proposed it should be an offence if any person purports to be an officiant and deliberately or recklessly misleads either of the couple about their status as an officiant or the effect of the ceremony. And we also proposed it would be an offence for any authorised officiant to deliberately or recklessly mislead the couple or either of them about the effect of the ceremony. So it's important to, I think, capture within that people who are purporting to be officiants as well as those who were actually officiants, because one of the weaknesses with the current scheme is that there are the penalties tend to apply to those who are regulated and not those who are unregulated.
I think that's a very sensible proposal, I must say. Well, that brings us to the end of today's session. We are running over time. And firstly, I just want to say thank you very much to all my guest speakers who have provided really important information to everyone. So thank you very much. And again, to everyone who signed up to attend today's session. So thank you, everyone. Bye-bye.
thank you, Nazia, for organising it.
Agreed.
Thank you, Naz.
Pleasure.
Thank you.
Yeah.